So let's jump into something, Joe. Let's talk about titles. So when I say a title to a piece of real estate, what literally does that mean?
All of the land in Georgia has to be basically recorded, right?
Right.
So there are parcels throughout the whole state, and so there's land records.
Right.
And that's really what the title, if you're associated with, it's like a car.
Yep.
Every time you transfer the same car, you transfer a title, and it's recorded with the Department of Motor Vehicles.
Right.
And so that's the title. Well, the land is the same way, but it goes into the land records at the Clerk of Superior Court of each county. So every county has all these parcels, and every time a seller and buyer interact, and there's a transfer, that's recorded in their land records of that county.
If you and I sit down, I'm going to transfer my title to you. I think there's 3 or 4 ways that I can do that. And so let's talk about those. And it's important for people to understand.
The one that gives me the most guarantees, if you're giving it to me or transferring it to me, selling it to me, the one that gives me that is the general warranty deed. But basically you're saying, I'm guaranteeing you this title is clear of all liens all the way back to forever.
Yep.
And so that's the general warranty deed. It's the highest, strongest deed.
So talk to us about how a limited warranty deed is different than a general warranty deed.
The limited warranty deed says the same as the general warranty deed as far as what you're guaranteeing, but only for the time that you've owned it. So what happened before you owned it and what happened when you release it, that period of time, you're not damaging it and not taking care of what you've put on the property, whether it's a mortgage or something else has happened, some type of lien. So you'll guarantee it for that portion of the time that you've owned it.
You also have lots of special deeds. You have a sheriff's deed, you have a trustee's deed, you have all of these different kind of deeds. But those aren't necessarily unique. They're just describing who it's coming from, but it's still either a general warranty deed or a limited warranty deed or the third type of deed, which would be a quitclaim deed. So number one, am I correct on that? And then number two, what's the difference in a quitclaim deed and a limited warranty deed and a general warranty deed that we've already discussed?
So the quitclaim deed says, I don't know if I own this property, basically. Of course, they know they own it, but they say, I don't know if I own it, but if I do own it, it's yours.
Yeah.
And I'm not guaranteeing anything.
Yeah.
So I could quitclaim, your house to somebody else. It wouldn't mean anything because I didn't own it.
So I'm transferring title to you, or let's just say, for example, you're transferring title to me. All my listeners know that Tammy and I are engaged. We're going to be married next year. So let's just say we're buying the property together. And I have one of 2 options for how I take title to the property. One would be tenants in common, one would be joint tenants. Talk to us about that, and let's talk about the rights of survivorship, because I think in many cases, people don't really understand how that works, and they've got multiple things going on in their background that prohibit, something that wants to be used this way for something else.
So when you take title to a property as a couple or as 2 different individual people, you can take it as tenants in common, which means you divide that by 2.
Yep.
And you could have tenants in common in a variation. Doesn't have to be 50-50, it can be 70-30. That tenant in common language means you could actually sell your share to somebody else.
Right.
You're 2 individual people, one can break off. What'll happen is if they don't agree on things, ultimately that tenant in common, one could sue the other and say, buy me out or sell the property.
Right.
But what I think you're thinking about is how does that happen when someone dies? And so we'll look at that later on. So that's a challenge. So people go, well, we have tenant in common. Well, it's a husband and wife. We know that ultimately if one of us dies, we want the other one to have it. And instead of having to go through the whole probate process, we can do something called a joint tenancy with right of survivorship. Mm-hmm. And so that happens, one spouse passes away, and then the other spouse automatically owns 100% of it, so that you don't have the probate process that you would when one of the spouses dies, because they know they want it to go to the other. And so that's the rights of survivorship.